Coon Rapids Townhome Forum. Tonight we have Phaedra Howard, an attorney with Helmuth and Johnson, and she's going to be talking to us about negotiating management contracts and answering any of your questions regarding that. So, but I just want to welcome you here tonight. My name is Kristen DeGrand, neighborhood coordinator for the city. I'm the one who organizes these events, and if you ever have any ideas for future meetings, topics, or guest speakers you'd like to have come in and talk with you, please let me know. My business card is on the back table, and with that, I will have Phaedra get started on her presentation.
All right, thanks. Negotiating that management contract. Better? Okay. All right. So first of all, who can manage a community association? You might be surprised at the answer, maybe not. Some associations have a direct employee that's an employee of the association. If you have your own employee that's a manager that's working directly for you, that employee can perform administrative, financial, and management duties for the association. So no issues there. You certainly are also free to hire a CPA or bookkeeper to manage your accounts, do your accounts payable, accounts receivable as part of their normal accounting services. And I know a lot of associations that are self-managed but use a CPA or bookkeeper solely for their financials. But here's the kicker that some people don't realize. If you are an independent person, meaning not an employee of the association, an independent person or company, if you're contracting with the association for professional management of the property for any compensation, and that would include a waiver of assessments, you must have a real estate broker's license or be affiliated with a licensed broker. I've run into a lot of situations where associations will take one of their homeowners, maybe a former board member, and say, oh, you did such a great job, let's hire you as our manager now. If they are not a licensed broker or affiliated with a licensed broker, they are not permitted to do that. That's in violation of the Department of Commerce rules, and they can get a hefty fine for that. So be aware of that, and if you're doing that, stop. Find a licensed broker that can do that for you. And again, when you have a homeowner doing that, managing, even if they do have a license, there's also a concern about, does that pose a conflict of interest? Because now you've got somebody who lives there in your association with you, is a homeowner, has the same obligations as everybody else, and is also acting as a manager. And that person is going to have obligations, presumably, to do things like send out violation notices, collect assessments, that sort of thing. It becomes very difficult when they're the ones that are in violation or not paying their assessments, etc. So I certainly do not recommend, even if you have a licensed broker that lives in your association, to have that person managing the same association. Not a good idea. Any questions on that? Yes? A paid person, right. And that would include if you're waiving their assessments.
Yeah. So
that's compensation, that counts, yep.
So if they're a straight volunteer, that's not the issue.
Straight volunteer, but if they're getting paid to do it, then they have to be affiliated with a licensed broker. Yes?
Does that include, would we hire somebody to be our management company? They manage several associations. They have to.
That management company has to be affiliated with a licensed broker.
Okay.
And most of them are, but you can easily check. You can go onto the Department of Commerce's website and do a search. Sometimes it's hard because it might be a particular person that has the license. It might be the company. Sometimes you see things where, a broker just plans their, come and affiliate with me so that I can manage properties kind of thing. So it's not always easy to find the information, but if you search under the names of the companies and the people that you know, the owners or whatever, something ought to come up as somebody having a license. And certainly you can ask the management company if you're not sure. Who is your broker? All right. So now we know who can actually manage an association. Let's talk about the different types of management companies and what you should be looking for when you're, say you're looking to find a management company. Either you're looking to change to a new management company, or going from self-managed, now you want to hire a professional manager. So, and certainly in the metro area here, there's the whole range, everything from 1 or 2 people working out of their house, all the way up to the national companies that in a lot of cases have moved in, bought the local companies, and now they're part of this national conglomerate, and everything in between. And so knowing that there's that range, obviously there's going to be a different range of services that can be provided by those different types of management companies, or even within the sort of categories of management companies, you're going to see that there's different ranges of services that they can provide. So when you're looking to go out and find a management company, I do recommend first thing you should do is put together an RFP. And that seems to be one of the things that is very difficult for a lot of associations to do or understand before you go out and find, and this is not just for management companies, but really any big vendor that you're working with or potentially working with, you need to know before you go interview those potential vendors, what is it that you're looking for? What is it that you want this company or this person to do for you or for your association? So put that together, put a list of what it is that we want from a management company. Do we want full management? Do we want financials only? That's an option with most at least the larger management companies. And again, maybe if you want financials only, you can work with a CPA or a bookkeeper instead of a management company. But what is it that you're looking for? And then once you figured that out, you know, what kind of level of control do you want the board to have over the management company? Because that's going to differ quite a bit between different management companies. Some of them, the management company basically comes in and says, we're going to take over control, you're going to do things our way, and that's how it's going to be. And some associations and boards like that. I've worked with some that went from a small management company to one of the big national ones, and so I had the conversation with them. And I told them, you understand that this company that you're interviewing has their own way of doing things, and they're going to require you to use all of their vendors, et cetera, et cetera. They said, yes, thank God, that's what we want. We're too busy to deal with that. And that's fine as long as you understand that. Other boards say, no, we want to be on top of and in control of everything that that manager or management company does. So that's something you need to understand going into that so that you can interview those companies and find out that information. How do they work, and is that going to work for you and your association? So once you figure that out, put together the RFP, and then you don't necessarily have to send that RFP out to the management companies, but at least have that internally, if nothing else, so that you know what it is that you're looking for and can ask the proper questions. Then check their credentials. Who are these people? What do we know about them? Ask for references. Talk to other boards and associations that work with them. Are you happy with them? Are you not? Why or why not? Those sorts of things. Are they members? There's several trade organizations in the Twin Cities. CAI and CIC Midwest are the two main ones. They might also be members of IREM or some other more real estate organizations. But are they members of any of them? Are they involved? Do they go and get additional educational training? What kind of skills do the managers have? What do they do to keep up with what's going on in the industry? So check all that out. Don't be afraid to ask those questions. I don't understand when I run into boards and say, oh, I don't know, we heard of this people, so we're going to go with them. You don't have to. There's so many options. You know, ask around, because most of the time, once you end up in a management contract, you're going to be stuck there for probably at least 2 years. So make sure it's somebody that you can live with and be happy with for that time period. Don't go into it blindly. And then again, we talked about the level of control. Know what level of control you want to have over what the management company does. I've had some boards that say, we want to keep our own bank accounts. We don't even want them, they can, have authority to authorize payments once we've voted it to approve it, but we want to keep our own banks, that sort of thing. And then again, like I mentioned, the other end of the spectrum, some say, let the management company do all that, that's fine, we're too busy to deal with it. So know what kind of level of control, and again, get referrals. One of the things that you should look for when you are talking with management companies, a lot of them, especially the larger ones in town, have affiliated businesses that often will be a maintenance company. Some of them actually have collection agencies that are affiliated with the management company, and that would be either owned by the management company or owned by the same persons that own the management company, or related persons or entities. So they have these affiliated businesses. And in a lot of cases, it's those affiliated businesses that actually are the money makers for the management companies. It's not your management contract for, $1,000 a month or $400 a month or whatever it is that you're paying to that management company just to manage you. They get a lot of their money, the bulk of it, from these other affiliated businesses where they come in, we'll manage you, and then we're going to refer you out to use our maintenance people or our collection agency or whoever it is. And that's fine. There's nothing wrong with having those affiliated businesses. But you need to understand, one, that that's the case a lot of times, especially, like I said, with the larger companies, and know that they need to disclose to you what those affiliated businesses are, and let you know that you are in no way obligated to use their affiliated businesses. So if you're talking with a management company that either doesn't disclose those business relationships to you, or tells you or infers that you have to use those affiliated businesses if you want to do business with them, that should be a red flag to you. That's not how it's supposed to work. They can have the affiliated business, you can have the option to use that affiliated business, but they have to disclose it and they have to tell you you don't have to use those businesses. Some management companies that maybe don't have their own affiliated businesses, a lot of them still have preferred vendor relationships. And again, there's nothing wrong with that. It could be simply, we've used these people in the past, they do good work, we like them, they're easy to work with, they're reasonably priced. So, if something comes along, we're going to suggest them as at least one of the options that you can use for your plumbing or whatever it might be, lawn care, et cetera, et cetera. And again, that's fine. The issue or the red flag would be if they tell you you have to use that company, or, and it's harder to figure it out, but are they getting some kind of referral fee? Are they getting paid, compensated to send business to these other vendors? Because then it's not an independent referral, it's something that they're going to refer you out in order to get compensated themselves. And that doesn't happen that often, but certainly if you hear about that, that should be a red flag to you that maybe this isn't the management company for you. All right. And again, whether they're getting the referral fees or not, if they're requiring you to use preferred vendors, and that's not something that you're interested in, again, some associations say that's fine, whatever. But if your association is one that wants to have more control over your vendors, then you should certainly be alerted to any management company that's going to say you have to use our people, whoever our people are. Yeah?
Is there any legal penalty for non-disclosure?
Is there a legal penalty for non-disclosure? I'm not aware of it. Potentially, if there's somebody that's licensed by the Department of Commerce, which again, the management company would have to be, depends on what their affiliated business is, whether that business is licensed. I'm not aware of any penalties. I'm not aware of any specific penalties, but certainly, if they're not disclosing that to you, that you should be asking why. Next. We know that, or maybe you don't know, but certainly I've been around long enough to know that there is a high volume of turnover in managers and management companies. Some managers get burned out very easily and leave the industry. Others get recruited by other management companies, and so there's a lot of movement. So even if you sign up today with a management company and they say, here's your manager, Joe Schmo. Joe may not always be your manager. Joe may not always be with that management company. Joe may decide he wants to go mow lawns for a living or whatever. So one thing that I recommend that you ask when you're interviewing management companies is what kind of level of input will they give you on the selection of your manager? Even within a management company, there's a lot of different personalities, a lot of different managers. Some may work very well with your board and others may not. And so do you have the ability, if whoever they decide to assign to you isn't really working for you, do you have the ability to request somebody else? Do you get a chance to interview that potential manager and find out if they're going to be a good fit with your association? And sometimes it's just simply with the own internal workings and management of portfolios, particularly with the larger management companies, that there may not be an ability for them to request your input. Okay, this person's leaving, or we're rearranging things, come and sit down and interview 10 people. I'm not suggesting that that should necessarily be the case, but if they're saying we need to make a switch for whatever reason, can you, before they pick somebody, at least tell them, here's the things that we're looking for, or if that person that you assign to us is not working out, can we request a change? And how easily would that work? And then the other thing that you should certainly be aware of is those standard management contracts that every management company has are absolutely negotiable. Don't let them come in and say they're not. Don't think that you can't negotiate. If you run into a management company that is not willing to negotiate any of the terms of its contract, go somewhere else. There's tons of them that will. They have their standard boilerplate language that they've drafted, and they all know that, that's not going to work. It's not a one-size-fits-all for every association. So if a management company is not willing to negotiate with you on those, at least on those terms that are of most importance to you, again, maybe you should keep looking and look elsewhere. Questions on that? Okay. All right, then we're going to talk about some of the common provisions in management contracts that you should at least be aware of, so that when you're going into meet with management companies or you're looking at their contracts, these are things that you should be looking for, talking about, discussing with them, possibly negotiating if they're not worded the way that you would like. So the first thing that you should be aware of or look at is the length of the contract and the provisions for termination. Not all, but probably the vast majority of association documents that I've seen have either in their declaration or their bylaws provisions that restrict the association's ability to enter into a management contract. They'll have language that restricts the term of that contract to usually 2 years. I've seen one, that you can't enter into a contract that's longer than 1 or 2 years. And then it also has to provide that that contract can be terminated with or without cause upon certain days, 60 or 90 days notice by either party, or usually 30 days notice for cause. And so the first thing you should do is look in your governing documents and see if you have restrictions like that. Again, it's maybe in the declaration, might be in the bylaws. Once in a blue moon, I've seen it in the Articles of Incorporation, but it's usually in one of the other 2 documents. And it's going to have language like that. So that is going to restrict the board's ability to enter into a contract. In fact, I got a letter today from another attorney who's concerned about the association having entered into a 4-year contract with the management company because their documents say no more than 2 years. And so they really didn't have the authority to enter into that 4-year contract in the first place because that exceeded what was allowed in their governing documents. Yes?
Ours is a 1974 document, so if there's no language about management companies in there, does that prohibit us from having a management company?
No, shouldn't. It's just, again, one of these things that's written into a lot of association documents, and we write it into the ones that we draft as well. But you may not have any language in there. And that, I'm just pointing out that's something you should look for right off the bat to see if you have that kind of language in any of your documents that restricts the length of contract. Because that would be something then you may have to negotiate with a management company. It says they want a 3-year, our documents say it can't be more than 2. So it needs to be a 2-year or we can't work with you. And unfortunately, a lot of associations don't know that, don't realize that, and they go and sign these contracts for longer terms. And then, maybe down the road, and we'll talk about this in a little bit, what happens if things aren't working out and you want to get out of it, and now you've signed this contract that doesn't let you out, even though your documents say that you're supposed to have this out. So that's something that you should look at and make sure that if you have that language that you are negotiating that term so that it fits with your governing documents. And the same goes not just for the length of the contract, like I said, but also for termination clause. So can we get out with or without cause upon the required number of days notice? And I recommend having that in there even if your documents don't say it, so that you are free to move to another company if things aren't working out. But certainly if your documents have that language, you really have no choice. And a lot of the management companies don't want to let you out early because there's a cost to them of having to bring in a new association, get up to speed and all that sort of thing. And so it costs them money. And I've had this conversation with a couple of the owners of the big management companies that, they'll say flat out, it's not worth our while if this association is going to leave after a year or 2. We want them locked in. And then, they might offer you some incentives of a reduced rate for a period of time or whatever. And again, if you don't have restrictions in your documents on the longer term, that's fine. But you need to know if you do. And then again, I would still recommend having that language allowing you to get out with or without cause. Because if the contract says that you can only get out early if it's for cause, then you end up having to argue what really is cause to terminate. And that can end up being a legal battle that you don't want to get into. Again, a lot of them have an auto-renew clause that says, okay, it's a 2-year contract, but then it's going to automatically renew for another 2 years and another 2 years and another 2 years, et cetera, unless you give us notice so many days before the end. And that's very typical language, and a lot of different industries have those kind of auto-renew clauses. Some of them now are more regulated by law. The association management arena is not so regulated. But those auto-renew clauses can be dangerous too. Again, basically if they're not allowing you an out other than to not renew, then you have to make sure that you're up on top of that if you want to find another company, change to a different management company. And that can be a problem if that auto-renew period falls within, say, close to your annual meeting, and now you've got a turnover of board members, and that's probably not the first thing on anybody's mind is, oh, we have to give notice to the management company that we want to terminate because you've got new board members coming in and that sort of thing. All right, so there's that. Then once we get into the actual nuts and bolts of the management contract, absolutely essential to have it spelled out as clearly as you can what exactly is and is not included in the standard management fee. And that will include things like their accounting support, how many meetings are they going to attend for that fee, What else are they going to do as far as coordinating with vendors, responding to maintenance requests, obtaining bids for you? If so, you might want to spell out how many bids they have to obtain for certain types of projects. And just as important as spelling out what is included in that standard fee is also spelling out what is not included. And are those other services available for an additional fee? And if so, how is that additional fee calculated? I've seen a lot of them that are really vague and hard to figure out. And I don't know by looking at it, okay, well, if they want this, is that included? Isn't it? And if it's extra, how do we figure out? You know, and a lot of times you just get a bill. And it's, okay, well, we're charging you extra for this. And then usually the management company has the authority to pay themselves from your checking account. So, you know, you don't have the ability to question those bills at that point, or not as much. So know ahead of time when you're going into it. And ask them to spell out whether it's, you know, an exhibit attached to the standard contract, or however they spell it out. What is not included, and if we want those extra things, what is it going to cost? Sometimes the agreements will say, for example, attendance at meetings. Okay, we'll attend 12 meetings per year for a maximum of 90 minutes per meeting. Okay, well, what if we're at a regular board meeting that we think shouldn't last more than an hour, and suddenly, you know, half the membership of the association shows up because they're all in an uproar about something or other, and now this meeting that should have been an hour is 4 hours. You know, it's a little harder at that point for that manager to say, okay, just so you know, 90 minutes now, we're going on the clock. But so that's one example. But other things, it's much easier for them to say this is going to be an extra charge, or maybe you're having an extra meeting. You know, we have a request to meet with a homeowner, or whatever the case is, we're having an extra meeting, we want you there. There they can certainly tell you, okay, that's not part of the standard contract, it's going to be so many dollars per hour, et cetera, et cetera. So the more you can have that spelled out ahead of time, you know what you can expect for expenses. And you can also call them to the carpet if they try to charge you something different than what they've said in the contract. And if they have a website, if they're going to host your website, then you want to make sure that your contract spells out everything about that. What content will be on the website, who owns that content, who has administrative rights to it, who can make changes or post items to that website, et cetera, et cetera. And that's becoming more and more common. I think certainly all the big management companies and a lot of the smaller ones will offer that as part of their services, that they'll host a website for you so that your homeowners or your board members can log in and access certain information. So you want to make sure that you know who can access it, how is it going to work, who owns that content, et cetera, et cetera. Questions on that so far? Okay. Next, a lot of associations have employees. Some of them are direct employees of the association, much more common in order for the association to avoid having to pay all the unemployment and workers' comp and all of that themselves, is that the employee goes through the management company. So they're actually an employee of the management company, but they're kind of handpicked by the board to work on site at our property, and that's quite common. So if your association has that situation, or you're maybe looking to have an on-site person like that, then again, your management contract should spell out exactly how that's going to work, make it very clear who the employer is. We've had some vague situations where the state now wants to come after the association for unemployment or workers' comp or other things that they think the employer should be paying into. And now it becomes a dispute. And this has been sort of an area of a lot of change, you know, who's an employee versus an independent contractor. And so if you've got this situation, you want to make sure that your agreement spells out they are absolutely an employee of the management company, not the association. We don't want the association to be on the hook for paying all of these things that the employer should be paying and doing. And then it should also state what level of input, if any, that the board then has in that employee, because they're still working for you. They're working on your site at your property. And same with, your assigned manager. If they're not working for you, you ought to have some ability to go to the management company and say, we want to change or fire them or whatever. And also through your management contract, it's going to have some language that requires the association to reimburse the management company for that employee's salary, benefits, etc. So you should have some say in how much you're going to pay that, or reimburse the management company how much they're going to pay this employee. But again, you still want it spelled out so that at the end of the day, you might have input, but you are not the employer. And so that's something, obviously, it doesn't need to be said. I don't think if I'm here as an attorney talking to you about management contracts, do not ever sign one without running it by your attorney. So your attorney's going to be looking for these things and talking to you about them. Yes?
Yeah, I see the word attorney in here, your association's attorney several times. So do all associations have attorneys? And we just have common grounds, we don't have houses involved, but we have playgrounds and paths and common grounds. So do associations generally have an attorney?
They absolutely should. You're a corporation. You are a business. It's a nonprofit, but you are a business.
So even
So,
if you don't have houses connected, it's just the property, you should still have.
single-family home association? Yeah, but you're still a corporation. Occasionally you might see, some associations that actually have CPAs and attorneys and those sorts of people. Although, frankly, when I run into an attorney as a board member, it's a nightmare because they're a personal injury or a family law attorney or something and then decide that they absolutely know more than I do. So I don't like attorney board members, but if you have those people qualified in your association to do all the things that a business should be doing, that's great, but most of the time you don't. We've got regular people that, hopefully, have a good head on your shoulders, but you may not have that a business or financial or legal background, and that's why you rely on your professionals, your accountants, your lawyers, etc., to give you professional guidance so that you can run your corporation the way it should be run. All right, so we were talking about employees. Insurance. A lot of management companies will, as one of their services that they provide, will help you manage your insurance. Help you get bids, make sure that your policies are up to date, all of that sort of thing. If they are doing that for you, your management contract should spell out that they have to give you notice within so many days of the renewal of your policies. If they receive notice from the insurance company that the insurance company is either not going to renew you or even terminate you early for any reason, you want to require that the management company give you, the board, that notice as soon as possible so that you can take action. If you want to change management or insurance companies or bid it out to get more information and that sort of thing, you want to be able to do that and take action within the appropriate amount of time before your policy lapses or you're locked in for another year. If you're not having the management company handle those things for you, obviously that should be clear in your contract as well. But I think the vast majority of associations that I work with, even ones that do financials only, usually have their management company handle the insurance for them as well. If your management company is helping you prepare a budget, then your agreement should probably state something to the effect of the manager needs to have a draft budget to the board by X date. And that X date should be in sufficient time to give the board the ability to review it, make changes, et cetera, before you need to adopt it and have it go into effect for the next year. And that's something that we often will negotiate with them. And, the managers, a lot of associations have their fiscal year ending around the same time, and so you're all doing budgets at the same time. And I think things are probably starting to wind down now, but I know September and October are really busy for managers trying to get budgets together. And so, you might want to give them a little leeway or say, hey, if ours falls in that time, maybe we want you to give it to us 60 days ahead of time so that you're not scrambling. You know, whatever works, but make sure that the contract has that language that says they have to get that to you by a certain date so that you can then take action, ask questions, et cetera, do your due diligence before you have to approve that budget. Maintenance and repair. Unless you're doing financials only, most management companies will be involved in whatever the association's obligations are for maintenance and repair of the property. And so they're going to be the ones that will field those phone calls from your homeowners of I'm having this problem or that problem, or you need to come look at this, et cetera, et cetera. They're also usually going to help you with your bigger projects. So we're seal coating the driveways this year, or we're getting new roofs, or whatever you're doing. They're going to be involved in helping you do that. That's part of what their job is in most cases, and that's great. But you want to make sure that if they are involved in that for you or with you, that again, your management contract is going to spell out how that process is going to work. And is there a difference if it's a smaller project or an emergency repair, that sort of thing, versus a larger project? You usually want to be able to give the manager or management company enough authority and ability to handle certainly those emergencies, you know, without having to wait. Okay, we have to call a meeting of the board and get a quorum together and get approval for me to call somebody to go stop that water spewing from the broken pipe. That's ridiculous. We don't want to tie their hands so that they can't handle those emergencies. So your contract language should give them enough freedom to deal with that, while still making sure that you have control over them when it's not an emergency. And so a lot of cases you'll see the management contract will set a spending limit. And I think that's a really good idea so that they don't have to bother the board with every little minor maintenance request. A lot of times it'll be $1,500, $2,000, whatever the number is. We'll say, we give you the authority to spend that money on a particular maintenance issue without having to come to us for approval beforehand. And you need to be careful, make sure you trust the manager before you give them that authority to spend that money. But that's very typical, and that might be a situation where you want to review that, see what that spending limit is, negotiate it to an amount that you're comfortable with. And then you also want to look at, does that language allow the management company to also write checks to itself within that spending authority, or are you limited to certain types of third-party payments? And I'm not going to name any names, but I heard stories recently where a management company had this authority. I think it was a $2,000 limit, and so they were involved in a big project, and they decided that as managing the project, we're entitled to extra fees, so they just generated invoices and paid those invoices for magically just under $2,000 every single time, to the tune of about 40 grand that the board never knew about. So again, that's an allegation. I don't know if it's true or not, but that's kind of scary to think that that could happen. So that's, again, one of those things you want to make sure that you look at, you have your attorney look at, so that you can make sure that the management company doesn't have that carte blanche authority to certainly go and pay themselves or their affiliated companies that kind of money repeatedly without ever going to the board. All right, and then the final one on this slide, obtaining bids and signing contracts. Again, we're talking about the larger projects where it's not just so-and-so has a leaky pipe or a hole in their siding or whatever it is. We're talking about the big projects where you're going out, doing some renovation, repairs, improvements, whatever the case might be, or repairing storm damage or whatnot. where it's a big project. And in that case, you certainly want to have your manager gathering bids for you to bring to the board. And a lot of times the management contract will specify it has to be at least 3 bids or whatever. Then the question always comes up, well, what if we sent it out for bids and only 2 companies were interested? Do we have to keep going till we find a third one? Well, that's, something that maybe you want to write that in. They can get permission from the board to get less than 3 if one of those situations arise. But that's, again, something that you as a board would have to determine. What do we want? What do we want the management company to do as far as assisting us with getting these bids? And how is that process going to work? What do we want? And then signing contracts. Never, never, never should the manager be signing contracts. Somebody on the board, preferably an officer, should be signing all of those contracts. Should never be the manager. And there's a couple of reasons for that. One, when we take on a new association as a client, a lot of times it comes as a referral through the manager and they want to, oh, here, I'll sign it. No, you are not our client. You are not our customer. You are simply their agent. I want my customer to sign that because they're the ones who are going to be on the hook. They're the ones who are obligated to pay me for my services. And so if I have any issue, I want it to be them, the board, not the manager. And secondly, again, yeah.
So if a board member, just an association, someone who lives in the association, first of all, we can't keep the board, but if a board member is the one that has to sign the contracts, do they need to worry about having their own attorney look at the fact that they signed their name to a contract? Or does the association's attorney be the person to, a lot of us might not want to sign any contracts. I'm just wondering, how do other people handle that? Who looks at to be sure that we're signing something that isn't going to come back to haunt us?
Yep, and again, that should be, the association should have an attorney, and then that attorney should be reviewing the contract. As a director or officer of the corporation, and this is getting a little off topic, but as a director or officer of the corporation, you are insulated from personal liability. So that but just because you're the one who signs on behalf of the company doesn't mean that that vendor can come after you personally if the association doesn't pay or doesn't perform. There are limited circumstances where you might be responsible if you're acting outside the scope of your duties as a director or officer, but as long as you're acting within the scope of your duties and you're not getting compensated, then you are insulated from liability for not just you're already insulated from liability for debts of the association, but also for your personal actions.
So advice to any of us here who have trouble keeping a board. In our case, you're supposed to change the board every 3 years, and occasionally we have that happen, but sometimes we have no board, we have 1 or 2 people doing everything. So, any suggestions for what you tell your people in your neighborhood if you've got nobody that wants to take action, because all of this is a lot of work too.
Absolutely, and it is absolutely a thankless job to be on the board of an association. I don't have a magic answer to that. Hopefully you have enough people that care or can be encouraged to care about what happens. This is your money, this is your property. And if we don't take care of it, nobody else will. And so, for most people, this is the biggest investment that you have, and you want to protect that. And so if you can't get people to run for the board, to serve on the board, who's protecting, if I'm a homeowner in your association, who's protecting my investment if nobody cares enough to even have a board or to have meetings? If you don't have a sufficient board, technically you can't do anything. You can't hire vendors, you can't make decisions, you can't do anything if you don't have at least a minimum number of board members. Your documents are usually going to say you need a quorum. So if you're supposed to have a 3-member board, you have to have at least 2 people to make a quorum, and they have to be at every single meeting, and they have to agree. Because otherwise, if you're 1 against 1, nothing passes. Yeah, I don't have the magic answer, and that's where we see sometimes, and I certainly don't recommend it. I see associations sometimes offering incentives. I certainly don't recommend anybody trying to waive assessments or give discounts on assessments, because that's a whole other issue. But you know, maybe everybody who comes to the meeting, we're going to have a drawing for a gift card, or you know, those sorts of things. The more that you can make it fun like that, I think more people might be willing to be involved, but I don't know. Homeowner apathy, unfortunately, is a huge problem, and sometimes you get the board, you get a strong board, but then the rest of the homeowners don't care, you know, so it's the same people that are doing it year after year after year, until somebody finally says, I'm done, I'm retiring, I'm moving, I'm whatever, and then it's like, uh-oh. Yeah, I'm sorry, I don't have a magic answer, but you know, it's all the standard. You know, if you can build a better community through events or whatever kind of thing, I think that helps. But that's hard to do. A lot of people just like, you know, leave me alone. I send you my check, and I don't want to hear from you until you tell me what amount I need to pay next year. So, all right. So yeah, obtaining bids, signing contracts. I think we covered that. Any questions on that? Okay. So some more provisions that we should be aware of and looking at in the contracts. Collections. If they are handling the collections of your assessments for you, which I assume that even if you're, I've seen some associations have their financials with one company and their property management with another. I think that's odd, but whatever. Whoever's handling your assessment collections, you need to make sure that your agreement with them, your contract, spells out exactly how that's going to be handled, and it is in the way that the board expects. For example, does your contract give the manager any authority to make decisions or to settle accounts or anything like that without going through the board? And I know a lot of associations say, you know what, we don't want to be bothered, you know, with the normal day-to-day stuff. So we want the manager to be able to handle that, take care of it, and on top of that, we're going to give the manager authority to accept or approve any payment plan that brings the account current within 6 months or less. That's reasonable. If that's something that you want, write it into the agreement. Otherwise, then if there's any payment plan proposal by any homeowner, then that might have to come to the board, and now you might have to wait for your next meeting, and if you don't meet it every month, that homeowner's sitting out there and not paying anything until they hear back from you 3 months from now. So especially if you're an association or board that doesn't meet every month, that might be something that you want to consider, is giving some level of authority to the manager to take care of these more routine collection issues. But on the flip side, you don't want to abdicate complete authority to them and let them do whatever they want. And so you want to understand exactly what it is that they're going to be doing for you and not going to be doing for you. Are they going to, if they have an affiliated collection agency, are they going to be requiring you to use that and then referring accounts to that collection agency without asking you first? I've seen some management contracts that basically say, we have complete control over all of your collections and we'll do whatever we want, and we'll refer it out to the collection agency, and they're going to charge this and that and the other thing, and the board has no say. I don't recommend that. If that's something you want, at least make sure you understand what that agreement says, and determine whether or not that works for you. I have some issues with some of that because I've seen, yeah.
I'm just wondering, going back to the recommendation that associations have an attorney, is that something that your association attorney could be dealing with on a smaller scale rather than the management company and the collection agency?
The collections? Yeah, usually what happens, because we do a lot of collections for our associations, but usually it starts in-house at the management company. And they're going to, you know, somebody misses one payment, they're going to send a late notice and a letter and that sort of thing. And it depends on what your collection policy is, and if you don't have one, you should put one together so that they can follow that. But at some point then, okay, we've done all we can because we're just a management company. Now we're going to refer it out to your attorney to take the next step. Yes?
Okay, kind of in response to that then, I think 20 years ago, we had a CPA. Now, that CPA filed liens against people's property. In this day and age today, because that's 20 years ago, can a CPA file a lien against someone's property?
I'd be very wary of that, and that was going to be my next point about sometimes the management companies want to charge you for them drafting and filing liens. I'm not aware yet that Minnesota has issued an official opinion on this, but I know a lot of other states have said that preparing and filing lien statements and things of that nature, that's practice of law. And so if you don't have a license to practice law, then that's the unauthorized practice of law, and that can get you into trouble. And so again, I'm not aware that there's been an official opinion here, but I certainly agree with that, at least with drafting and filing lien statements against somebody's property. I think that requires an attorney to do that. Some boards will file it themselves. If you're not paying somebody else to do it, that's a different issue, kind of like we talked about being licensed to manage property. If you as a board are filing it, you're not going to get in trouble for the unauthorized practice of law. You may also not know what you're doing and not be doing it right, but that's a separate issue. But that management company, that manager, because they're getting paid, and a lot of times they'll have, I've seen, their list of here's the fees that we're going to charge you, and here's our fee for preparing a lien statement for you. That to me raises a red flag. They should not be doing that.
And if it's say you have a renter, a landlord-renter issue in your area, what kind of complications is that if you try to collect dues from someone living in your area and they're a renter?
Well, you shouldn't be collecting, the renter doesn't owe anything to the association. It's the owner of the property that owes the assessments.
The landlords are what we have to deal with.
Yep. So yeah, but the main thing here is understand what that management contract says about how those collections are going to be handled, and also, again, the red flags if the contract says that they are going to be engaging in the unauthorized practice of law, then I would say no, I don't think so. And at least let's negotiate that so that it no longer says that, and we no longer authorize you to do that, and we'll handle our own collections the way we want to handle them. Yes.
Do you put the conciliation court filings in the same category as the newspaper?
No, and here's why. Conciliation court is intended to be court for the people, that you can do it without an attorney. So that's really a different thing, because that is set up, intended to allow people to do that without attorneys. In fact, some counties, as attorneys, we have to ask permission to go to the hearings on behalf of our clients. But yeah, those lien statements are of particular concern to me, because I think that is practice of law. Another thing that would be of concern, again, is if they have a requirement that you use their attorneys rather than being able to pick your own. Because you don't have any say over when they refer the account to those attorneys. In some cases, they draft it that way. And certainly it's always, and I've talked to, and I know this happens, and, there's a lot of flux and movement, and, we get new clients, we lose clients, no big deal. But as board members, you need to know that you are the client, you have the choice of who you want to use, and nobody can tell you otherwise. So if you want to use a particular law firm and your management company is trying to tell you you have to use somebody else, then that might be something where you don't want to work with that management company. Again, other associations say, fine, whoever you use, we don't care. And if that's how you feel, that's fine. Just understand either way going into it what it is that you're getting into, so that you're not surprised down the road when the management company kicks it out to a law firm. Well, we've been using this firm all the time. How come you sent it there? Know if that's going to happen ahead of time. Insurance claims. A lot of associations at some point or another end up with wind, hail damage, broken pipes, whatever the case is. Does that management contract say anything about how those insurance claims are going to be handled, and what role the management company is going to play in that? Back in the day, It was pretty standard for the management contract to have language in that basically said, for an additional fee of, say, 10% of the total claim amount, which we will collect from your insurance company, we will help manage and process your insurance claims for you. That now is pretty clearly defined as being within the scope of a public adjuster. And so you need a public adjuster's license from the Department of Commerce in order to be doing that for a fee. And so if you have an older management contract that maybe has that language and you've been auto-renewing it every 2 years or whatever, it might be time, next time it comes up for renewal, you take a look at that and let's change the language and update it. Because probably the management company itself has changed their standard contract for that. If they're going to try to adjust your claims, make sure, and there are a couple management companies that either within the company or have, again, an affiliated business where they have a public adjuster. Somebody's gone out and gotten that license. And if so, find out. Get the name of that person so that you know if they're going to be doing this and trying to charge you a fee or referring you to their affiliated business, that it's legitimate and that they are licensed to do that. Otherwise, your contract should not have language. And have your attorney look at that, because they still, might say, okay, we're not going to do this. We're going to take 10% of the insurance claim proceeds or anything like that. But managing these insurance claims is often very time-consuming for them. And so there might be something in your agreement rather than the language of we're going to handle and adjust your claim for you. There might be something that has more language about our extra time, and we're going to be compensated for the additional time and effort that we put into this. That might be okay. It depends on the language and how it's written. So again, that's something you want your attorney to look at and make sure that it's written clearly that they are not adjusting the claim, but instead that they are being compensated for their additional time that they're spending on your association. Another thing that most management companies will do, offer to do, a service that they provide, is to fill out those resale disclosure certificates for you. When you got a homeowner that's selling and needs to get a resale disclosure, management companies like these are a fee generator for them. And so unfortunately, they usually write it into the agreement that that's all theirs. They charge the fee directly to the homeowner. They collect the fee directly to the homeowner. Nothing goes through the board. For those associations that are governed under the Minnesota Common Interest Ownership Act, that statute says clearly that an association, well, and actually everybody is as far as resale disclosures go, but that says that the association can charge a fee to the seller for filling out and providing the resale disclosure. There's no contractual relationship between the management company and the seller of that property. There's nothing that allows the management company to charge directly to the homeowner. And I've gone round and round with management companies when I'm negotiating this on behalf of the association. Ultimately, they're the ones who risk losing not being able to collect that fee if they don't have it structured correctly. But it should be set up, and some will agree to it and some won't, but it should be set up so that the management company charges that fee to the association, who can then pass it on to the homeowner. Because the statute allows the association to charge it to the homeowner, doesn't say anything about the management company. Question? Well, if you're in a single-family home, you are not required to complete those. But all condo, townhome, and cooperative associations, whether you're otherwise under the act that we talked about or not, have to provide a resale disclosure certificate to a new buyer. And that gives them information about insurance, what components of the property the association is responsible for maintaining, replacing, budget, all that kind of stuff. A lot of the single-family ones will provide it anyway because they think that's a benefit. Not for single family. Yeah, no, it is required by law for condos, townhomes, and cooperatives, but not for single family and not for commercial associations. So if it was an office condo, et cetera, they're exempt from that. All right. Other administrative fees. Again, you want to know if there's something that the management company is going to be charging to you, so that you can determine, look at your governing documents, or have your attorney look at your governing documents to determine whether some of those fees you might be able to assess back to homeowners. And an example, one management company that we used to do a lot of work with, they're no longer in business, but they had a standard, you know, anytime we have to do anything out of the ordinary, it's a, whatever the amount is, administrative fee that we're charging to the association, because, you know, whether it's dealing with a foreclosed property or a difficult home, or, I mean, there didn't seem to be any rhyme and reason in my estimation as to when they charged that fee and when they didn't, but you know, those sorts of things, if you're going to have that, make sure it's written into the agreement. A lot of associations, if you have a lot of rental properties, might find that just dealing with the administrative issues with those rental properties of, you know, making sure we know what's being rented, getting copies of the leases, all that sort of thing, the move in, move out, all of that takes up extra time of the management company. They may say, we're going to charge you extra for that. If they do, maybe something that you can pass on to your homeowners, depending on what your documents say. So those are all things that you should be looking for if there's something that you want to be able to charge to the homeowners. You know, a big thing these days is trying to get people set up on ACH. Can we get you set up on ACH so that we can make sure that your payments are going to come in on time every month, and it might save us money too, because the bank's not going to charge us as much to process the payments, et cetera, et cetera, et cetera. So is there a way that we can do that? And I know some management companies, well, actually I've heard some banks will charge the association specific fees for processing manual payments. So that might come from the bank, but that might also be something that you want to give incentives to your homeowner. Well, you can say, management company, right into this, that you're going to charge us a $25 per year fee for processing manual payments. Now we can pass that on to the homeowners, something like that. Again, just throwing that out there. But if there's something that you want to be able to pass on to the homeowners, you need to be able to justify that as an actual cost to the association that under your documents then allows you to assess to fewer than all units. And again, it depends on your documents, but if you have that language that allows you to assess common expenses to only those units benefited, then that might be something where you want to look at writing those costs into your contract so that there's a clear, you can clearly establish that this is a cost to the association that we're going to pass on to you. And then finally, the big one that I tend to fight with management companies about is their limitations on liability and the ability of the association to bring claims against them. It makes sense if you think about it. The management company is working for you, the association. They are the front line between you and your homeowners. They're taking the brunt of all the phone calls, good or bad, et cetera, et cetera. And so when they are acting as your agent, it makes sense that they're going to require you to indemnify them and pay for their legal fees if a homeowner or another party comes out and brings claims against them because of they're doing their job for you. So that makes sense. And so pretty much every management contract I've ever seen is going to have that language, and I wouldn't recommend a management company not have it. There's no reason if I'm doing something for you and I'm doing what you tell me to do, and then I get sued because somebody doesn't realize where the chain of authority is, and I get named in a lawsuit, you're going to defend me. And so that makes sense, and that should be acceptable to you. But then the question comes up is, how far does that extend? And on the flip side, then they turn around and say, okay, if we screw up and it costs you money, we're not responsible. And a lot of times the agreement, the standard language will say they're responsible if it's a willful act, like I knew better and I went out and did something. Possibly they might take responsibility for gross negligence. Almost never, at least in the standard contracts, will the management company agree to be responsible for ordinary negligence? And that's something that I always try to negotiate with them. Sometimes I win, sometimes I don't. But I want them to be responsible to you, my client, if they screw up and it costs you money. Things that they should know better. A lot of times it's, with the resale disclosures, for example, we've got an account in collections. And, we're in the middle of getting ready to foreclose on somebody. Management company knows that because they've got something in their system that has a notation that it's been referred out for legal collections, and then somebody calls up for a resale disclosure and, oh, well, let's pull up what we have here. Yeah, we only bill our legal fees to you once a month. So there might be something that hasn't been billed to you. We might have future fees that are coming into us or things that we have to do to release a lien, et cetera, et cetera, et cetera. They give a payoff, they are bound, you the association are bound by the payoff that they gave. And so you may be out hundreds or thousands of dollars because the management company screwed up. A lot of associations don't even realize that because the management company is not going to tell you that they screwed up. But things like that, you want to see if you can get them to agree that if they are negligent, they are responsible to you for that, for those damages that you incur because of their negligence. And like I said, sometimes they'll agree to it. More often than not, they're going to stick at gross negligence. But that's something that at least you should try to negotiate and get that in there. And then also they a lot of times try to place limitations on your ability to bring those claims. And so they'll say, you have to notify us within 6 months of the occurrence or you waive your right to bring a claim. Well, most claims in Minnesota have a 6-year statute of limitations. You have 6 years to bring that claim. And now they want to drop it down to 6 months or even 90 days. If you don't notify us in writing, you've lost your claim. That's certainly something I would want to look at before I sign that, because that's kind of scary. A lot of times you don't even realize it. You might be, dealing with a difficult transition from one management company to another, and still trying to get your financials or other documents 3 months later. And if they've got a 90-day notice provision, you may have already lost that claim. So those are things that you should be looking at and certainly discussing with your attorney before you sign those documents with those provisions in it. Questions on that? Okay. All right. So now you've signed that contract. You have the management company in place. Everybody's happy. Or are you? A lot of times, if you haven't done your due diligence ahead of time, you may find yourself in a situation where, for one reason or another, you're not happy with your management company. Maybe you don't like the manager that's assigned to you. Maybe he or she is falling asleep on the job, not doing what they're supposed to be doing. Maybe they're overwhelmed, have too many properties, or maybe, the company itself had some of these things that were in the contract that you didn't realize that this is how it was going to be and we don't like that, whatever the case might be. What happens? What can we do? Can we get out? Well, I recommend before you try to jump ship, talk to the management company first. Raise it up to the owner if you need to. Talk to them. Sit down and talk to them. What are their concerns? Maybe it's something that they weren't aware of. Maybe they can, like we talked about, assign a different manager to you. Maybe that's all you need. Maybe it was a personality conflict with that particular manager, or that particular manager wasn't doing their job. Maybe they get fired and whatever. So talk to your management company, or the owner of the company, and see if you can do, or a supervisor, or whatever it might be, and see what you can do about that. You can also go to your outside advisors. If it's a financial concern, if it's a legal concern, talk to your advisors and get advice from outside sources. Here's what's going on, or here's what we think is going on. Does this sound right to you? And a lot of times I get those calls, and it's just because the boards don't understand how things work. So it might be just me educating them, and this, the indemnification or whatever it might be. This is how it works. And so that is perfectly fine. Or no, it's not. They're screwing you. So talk to somebody and get that information, get that advice. If that doesn't work, and you can't salvage the relationship, then that's where we need to go back again to see, was your termination provisions in your management contract, were they properly drafted? Can you get out? Can you get out early without penalty, or what does that say? If you've got that language that allows you to get out with or without cause, see, is it a 60-day notice, 90-day notice, whatever it is, you just send the written notice and we're done as of this date, and you go and find another management company in the interim, or maybe you already have. Easy peasy. If you don't have that language, or even if you do, but they've locked you into a contract that you should not have signed that doesn't have that out, it's going to be a little bit more difficult. And sometimes I've gone to the management companies and said, hey, you should know, you've been doing this for how many years, you should know that the association has this language in their governing documents that says that they have to be able to get out with or without cause for 60 or 90 days notice. And so you as a management company should have known that, shouldn't have given them this contract that didn't have that language. Sometimes that'll work because really they should know. If they're a newbie, well, I don't know that they should be running their own management company if they don't have that much experience, but it is standard. Probably at least 75 to 80% of all association documents that I have ever seen have that language in it in one fashion or another. And so if you're a management company and you've been doing this for enough years, you've seen that, you should know better. So sometimes we can take that and say, yeah, I know they signed this, but they didn't have authority to sign that, and you should let them out anyway, based on what their governing documents say with the 60-day notice or whatever. Sometimes that works. Sometimes they say, no, they signed the agreement. It says that if they want to get out, they have to pay me another 5 months of management fees or whatever. And so then maybe you get into a fight then with them. And that's again where you might need to talk to your attorney, see if you can get your attorney involved. You may ultimately, especially if you don't have that language in your governing documents that restricts the length or the termination provisions of your contract, you might be stuck. It happens. We've seen that. We've had to advise associations, I'm sorry, if they're not going to let you out, there's nothing we can do. You are stuck, or you have to pay the penalty or whatever the contract says. But at least then you understand that. And okay, now, our contract comes up for renewal in January, so we've got, we give them a 60-day notice at that time that we're not going to renew, so we can start planning ahead. That's not the best case scenario, but at least you understand that. A lot of times, though, yeah?
Quick question. Is a management company legally bound to provide you with, say, a thumb drive of all your contracts, communications?
Not required to be on a thumb drive unless that's what your agreement says, but yes, those records, your association records, belong to the association. The management company is the temporary keeper of those records if that's how you set it up, which would be the case in most situations. But those records belong to you, and if they fail or refuse to turn them over, then you hire somebody like me to send them a nasty letter. And then finally, understand that if you, as an association or board, are not happy with the management company, if there's been fighting going on, whatever, it may very well be mutual. They may be thinking the same thing and wanting to get rid of you as much as you want to get rid of them. And so it certainly doesn't hurt, even if you don't have all the magic language in your contract. Go talk to them and say, we are not happy. Can we just agree to part ways? We'll pay you for the next 2 months, and then can we go? And a lot of times they will say, yes, please, get out of here, go. We don't want you anymore. Sometimes I've seen them say, oh, we are firing you now, you're done, go away immediately. And it usually is something major that the board has done to cause that to happen, but I have seen that as well. And so that's all I really have. We have about 10 minutes for questions, or we can get out early. Yes?
Okay, what you presented has been excellent, but it's also a lot of information that a lot of homeowners are new so homeowners aren't self-educated. Do you think a management company is better than having homeowners muddle through with hiring their own tree people, their own playground people, their own path system, and muddling through and getting advice here and there, but nobody ever knowing anything about anything and not wanting to read up on it? So far, we've been muddling through. But from your experience of seeing what can happen in associations, is it better to have a company than to be muddling through and piecing things together little by little?
I would say the vast majority of cases, I would recommend professional management. Again, as long as you make sure that you have the right professional management. Somebody who's going to steal money from you, for example, is not the right professional management, and you're better off without them. But if you have the right management company, and that's where we talked about, do your due diligence, do your research, get referrals, find out what you can about any of the management companies that you're looking at. Talk to other people in the industry. Talk to your attorneys, your accountants. Who do they know? Who have they worked with? Who do they trust? And get that information. But yes, I think for the most part, most associations would do well with professional management. That being said, I have dealt with a number of associations that are self-managed, and they're doing a fabulous job. We
Have a full board.
yeah, well, they probably do. One example, we have a client that we've worked with for a number of years, and they had a board president who was a retired engineer, I believe, very involved. I mean, he would go around and the biggest volunteer in the world. And he decided he was done. and I'm not running again. And so fortunately, he had at least one other, it was a 3-member board. And so there was another board member who'd been on the board with him for a while, and a great person as well. She still works full-time, so she doesn't have the time to dedicate it that he did, but she's stepped into his shoes. But you don't always have that. And so if you don't have those kind of dedicated volunteers who not only have the time, but have the energy and the know-how to do everything that needs to be done, which a lot of associations don't, and that's why there are management companies out there to take that pressure off of you. Yeah.
Phaedra, that situation that the 4 of us are in our community are 70 homes, individual homes with common property on each piece of the 70 homes. Now the bylaws were created in 1970. They've never been updated. They're obsolete. We can't afford an 8th grader who's good in math to really pay our bills. We have an active president, but he's done a marvelous job with no support. And he's telling us now he's going to be leaving. We have no one that's going to step up to that plate, unfortunately. And when we talk management companies, we're lucky we get the garbage bills paid. We're unlike any other association, I'm sure, in this room. I don't know what we're going to do. We can't afford to have bylaws because we couldn't afford you to do it. Even though we'd love to, but we couldn't afford you. We can't downsize the common grounds because that would be a surveying process that would cost hundreds of thousands of dollars probably. We're so unique. We're known as a PUD development, planned urban development, which seemed like a good idea back in the 1970s, but as it turns out,
Well, and if you are truly single family, of course, you said there's common properties running across the yard. So
Yes.
I'd have to wonder. I'd have to look at your documents and see exactly how you're structured. If you're truly single family and only have a common tennis court or something, it might be possible to just dissolve the association and everybody take care of their own stuff. That's harder to do if there's common property, or shared maintenance, shared walls, that sort of thing.
and John, Bill gets X number of feet of common property, where Sally gets less than that. It just opens up an entire process that I don't know how we can, as far as hiring an actual attorney to be on staff. We were just discussing this. We have access to one supposedly, but no one knows who that is. It's a phantom attorney out there somewhere that our president that does contact as needed.
It's been doing everything.
Yeah, I mean, I guess I would look at your documents and see what your ability is to increase the assessments to cover
Exactly.
your fees in order to be able to do some of that stuff.
Our fees could increase by what, 1%?
1% of $70 every
Yeah.
3 months,
So-
which will get you
what block?
Yeah, without looking at your documents, I'm not sure what your ability is, but if, yeah, increase those assessments as much as you can.
Right.
Yep.
Is there a common compensation plan, a range of compensation plans? Is it a percentage of rents collected or fees collected?
For management companies?
Yeah.
I don't know if there's common. Typically, they'll look at the number of units you have, and then whether it's townhomes or condos, et cetera, to determine the level that they would have to be involved in maintenance. And then I think they do kind of some of their own number crunching of how difficult or easy are these people going to be to work with based on, demographics or how many, rental units or whatever it is that they're looking at. I think there's typically a range, and if you contact any management company and tell them, the type of property and the number of units, they'll give you an estimated range, but they might differ within that range based on some of those more less objective factors. And then again, it's going to be, okay, well, how many meetings per year do you want us to attend? And some of those things are going to change the cost as well. And then there's wiggle room there. Say, okay, well, it's still a little steep for us, but how about if we say you come to every other meeting and we'll handle the other ones on our own? Would that reduce the fee? I mean, there's ways to finagle that so that you can get to a number that works for you. Is there a question over here? Yeah.
What's the state of, well, say 60 days from now and it's 60 below out and nobody wants to, leave the comfort of their home, can they have a virtual meeting?
Virtual meetings? Are you talking about boards, homeowners?
Yeah, a board meeting.
Yeah, the Nonprofit Corporations Act, which most associations are formed under, does provide that a board meeting is any way, or it is a board meeting if the directors can communicate simultaneously. So if it's through a telephone conference, any kind of web-based product, whether it's Skype or whatever, WebEx, those sorts of things, yeah, they can do that. There might be concerns if you're supposed to have open meetings and there's no way for the other homeowners to observe. That might be an issue with open meeting requirements if you're governed under the Minnesota Common Interest Ownership Act, which does require those meetings to be open to the owners. So there might be issues there, but you can have a meeting and have one or even all of the board members be participating remotely. What does not constitute a meeting is communicating via email, which we do a lot, but that doesn't constitute a meeting because it's not simultaneous. I can send you an email now. You might be at your desk, you might read it almost immediately, or it might be a couple hours or a couple days. You might be on vacation and not read it for a week. So there's no simultaneous communication there. So email is not a meeting, and there gets to be some issues with violating some of those meeting requirements if you're conducting business via email. That's a whole other topic, but I'm happy to talk to you about it afterwards. Was there a question over here? I thought I saw a hand. No? Yes?
I just wanted to comment that I served on a board and we terminated a management company, and rather than do it with the clause of with cause, we did without cause. And it was a lot easier. It was a little longer process, but we didn't have to give them a reason. It's just like thank you and goodbye.
Right, and that's exactly one of the reasons why you want to have that language in there and why that's written into a lot of your association's documents. It gives you the ability to get out without having to show that they somehow were at fault, that they didn't do their job. On the flip side, I forgot to mention we were talking about that, but sometimes you'll see that the contract will say, not only can you not get out before the end of the contract, but if you're not paying or for whatever reason, that they're going to terminate you with less than 30 days notice, sometimes a 5-day notice. And so if you've got that language in your documents, that's not okay either.
Okay, well, thanks everyone for coming tonight. Round of applause for Phaedra. again, if you have any questions or suggestions for future meetings, certainly let me know before you leave tonight, or you can take my card on the way out and send me an email or give me a call later. And we hope to see you again in the spring.